Okay, so welcome everyone to the fourth lawyer-led workshop, I believe, of this project. We're going to focus today on what happens when local authorities bring homeless duties to an end. So far, we've kind of went through the homeless legislation from the beginning. When can a homeless application be made? The duty to provide suitable temporary accommodation. And what we're going to cover today is situations where local authorities may or can bring their duties to an end. So the first issue, we touched on this in the last lawyer-led workshop, when local authorities discharge the duty to provide temporary accommodation, often due to the conduct of, or the alleged conduct of the homeless applicant. So I wanted to look at that in a bit more detail today, and actually that's what I've provided the case studies on. So rather than have the breakout rooms at the end of the session, we can do it after this first part, because I think these cases can be quite difficult and they're not always easy. So we can have a breakout session after we look at this issue, and then we'll start to look at permanent accommodation. What is a local authority's duty in relation to permanent? When does it apply? Can a permanent offer be challenged? Yeah, so we'll look at the duties of a local authority to make a permanent offer, when that applies, and if the offer is not accepted by the homeless applicant, or there's a reason why they don't want to accept it, can it be challenged and how? And then we'll look at basically other circumstances. So if the local authority decides that an applicant's not homeless, or that the applicant's intentionally homeless, or they've got no local connection, what does the council have to do in those situations? So hopefully that all makes sense. I'll just take it as it comes. I'm happy for you to put questions in the chat. Feel free to jump in and ask a question as we're going through the slides as well. I'll not necessarily be able to see Andy putting their hands up, so feel free just to unmute yourself and just ask a question if you've got anything as we go along. And hopefully with us doing the breakout session in the kind of first half of today's session, it'll give a bit more time at the end for any questions or anything that comes up as well. So yeah, before we look at discharge of temporary accommodation, I thought we might just recap on the right to temp accommodation. Again, this is going over old ground now that we've learned from previous sessions. But if the council have reason to believe that an applicant may be homeless, they shall secure that temporary accommodation is made available. And there's three circumstances that applies: pending a decision on the homeless application, or if there's been a review of a decision until that review is decided, or where the council have the duty to secure permanent until that permanent accommodation is available as well. So yeah, you can cross-refer to like previous slides and previous sessions on that duty. It's also important just to remind ourselves that temporary accommodation is only treated as accommodation under the Homeless Scotland Act if it's suitable. So if the accommodation is not suitable in terms of the unsuitable accommodation order, which we covered in whatever, I think it was the most recent session, that's important when we start to look at discharge of duty. And I think when we're looking at clients that may have support needs, mental health issues, addiction issues and so on, what can be quite important is that accommodation is unsuitable if it's not suitable for occupation by the household, taking into account the needs of the household. And helpfully the Code of Guidance on Homelessness expands on that. So those needs include taking into account protected characteristics, the qualities, considerations, vulnerabilities, and so on. Okay, so that's really just a quick recap. That's probably well ingrained by now. We've went over it a few times in recent sessions, but it is relevant to this issue of discharge and duty to provide temporary accommodation. And what I wondered, I would just be interested to see to what extent like this is an issue that you face with your clients and service users. Can I just ask Pauline or Jill, do you have access to the polls at all?
I have access, Chris.
Is there a poll there on this question?
Yes, I have a question here. Have you had a
Okay.
client or service user situation where local authority has discharged temporary
Yes.
duty? So I'll just launch that.
Thank you. Yeah, it's just to get a sense of everyone's like to what extent this is an issue that you face. As a restarter for 10.
Is everybody seeing that? Yeah. Yeah.
Can I just clarify?
Okay.
Is that different? Is that different to, like, so I had someone, I tried to get accommodation while I was out on the street and they were just told no because they were from a different area or whatever.
Right.
Is that a different thing to discharging, or is that the same thing? Would that be a...
Yeah, I think what you're describing, Esther, probably refers to some of our previous sessions where it's like the duty to accept an application and provide temp. Discharge of duty is when like the council have accepted an application, they're given temp, but then for some reason the client's lost it, or they've been thrown out, or refused accommodation. So yeah, slightly different scenario to what you're describing.
Okay, so I've shared that with everybody. Does everybody see those results there?
For some reason I can't see them, Pauline, so would you mind?
You can't see them. Does everybody else see them? Does everybody else see them?
Yeah.
Yeah.
What are they, out of interest?
Well, we have 60% say yes.
Okay.
And we have 40% say no.
Okay. Interesting.
Okay.
Okay.
So just stop sharing that now.
Yeah, thanks, Pauline. Yeah, well, that's interesting. So the majority have had a situation where that's been an issue. And it'd be interesting, we can bring that out in the breakout sessions, like what your experience is and whether you've been able to challenge it, how successful that's been. I'll talk through the issues as, from the perspective of our experience, and we can see where that takes us. But yeah, it's obviously not an uncommon scenario where temp accommodation is lost and it's due to the applicant's alleged conduct. There's really two approaches I've seen local authorities take. The first is that they may state or issue a decision that they've discharged their duty to secure temporary accommodation, and they might refer to the fact that somebody's broken the rules and the accommodation provider. There can be various reasons, and we'll come on to the case studies around that. Other local authorities take the approach that they have performed their duty and they do not require to re-perform it. So if the duty is to secure temporary accommodation for the occupation, if they've done that, they've secured it, they've provided it. If for some reason, due to the tenant's conduct, that accommodation is lost, local authorities may argue that they don't have to re-perform that duty. Okay, so it's a slightly different, it's a nuance there, but I'm just raising it because I've seen the kind of different approaches, and I think what's interesting is the language of discharge of duty doesn't actually appear in the legislation in the context of temporary accommodation. So it's not like the Housing Scotland Act says duty will be discharged if X, Y, or Z happens. Okay, and I think that's why some local authorities talk about, well, we've performed our duty. This possibly comes from some English case law as well, where the courts have talked about the difference between the existence of a duty and the performance of a duty. So yes, the duty exists to ensure that temporary accommodation is secured for a homeless applicant, but once it's been performed, it doesn't necessarily have to be re-performed rather. And so we've not yet had any cases in the Scottish courts on this issue, but it's just to highlight that there is a risk that a local authority may argue that it has performed its duty in relation to temporary accommodation and the courts accept this approach. Whereas I think what we want to advocate is the kind of discharge of duty scenario, because there's case law that I think might be helpful. We'll go on to talk about. So yeah, this is quite technical and nuanced, but it's just to hopefully explain some of the background and why you might hear different language. And it's not the most helpful that we've not actually got any case law in Scotland on this particular point. But then thinking back to like the duties on a local authority, if a local authority have argued that they've performed a duty, right? They've given temp, the client's then lost it for whatever reason, they've been asked to leave. Well, the important thing to check is, was it suitable accommodation in terms of the UAO in the first place? Because if it's not suitable accommodation in terms of the UAO, they've not performed the duty, right? So it provides a potential argument there to say to the local authority, well, look, you're saying that you performed a duty, you don't have to do that again, but in actual fact, the accommodation wasn't suitable in the first place. Okay. So I think what's important is like taking a note of any particular needs that the client has, where those needs met through that accommodation the client's provided. So if a client was put in a B&B and then they've lost that accommodation, but actually they've got support needs and supported accommodation would be more appropriate, should they have actually been provided with supported accommodation in the first place. Okay, so it's just thinking through like scenarios like that. And it's also worthwhile just asking the council whether they've actually assessed the individual's needs as well. Because if they have done and that identifies things that haven't been met, again, that allows that advocacy to take place and to argue that they should still provide temp accommodation. So yeah, sorry, this slide is just really making that point that if they do argue that they don't require to re-perform the duty, a failure to provide suitable temp will help to challenge the assertion that the duty has been performed. Okay, so I think that's just useful to flag and might be a helpful argument if you're dealing with a situation where you've got a vulnerable client that's the council saying they don't have to provide temp anymore. Okay, is that all making sense so far? Any questions around that? So what I wanted to look at now was a case in England. It wasn't actually under the homeless legislation. It was under the National Assistance Act. And in this case, the applicant was an asylum seeker. So they weren't eligible for homeless assistance, but there was other statutory provision. And this is the case of Cooge Team. So the applicant was initially in bed and breakfast accommodation, then in the hotel, then evicted from that hotel for the allegation of threatening to kill the manager. So quite serious facts here. Local authority wrote to him advising that it would rehouse him, but if he was evicted again because of violent behaviour or for breaking the rules, they would consider the duty discharged and not provide further accommodation. So yeah, quite serious allegations in that case. There was then further allegations, as you can see there. The applicant disputed those allegations and through legal advice, obviously representations were made to the council and the council refused to reassess his needs. The applicant took JR proceedings and asked that the court basically grant an order for the council to reassess his needs and accommodate him. There was psychiatric evidence of mental disorder as well. So yeah, this case is important because what the court held is that if an applicant manifests a persistent and unequivocal refusal to observe the authority's reasonable requirements, the authority are entitled to treat the duty as discharged. The court also said that it is desirable that a final written warning be given, but there's a requirement to carefully consider the applicant's current needs and circumstances. Okay, so this is, I don't know whether you've come across local authorities referring to this, but you do get local authorities to say, well, look, the person has persisted in breaching the rules in various accommodations, for example, and so we're entitled to treat the duty as discharged. What's also important, though, from this decision is that the court recognised that circumstances might change. So where the applicant can satisfy the council that his needs remain such as to justify provision of accommodation, and there is no longer reason to think that he will persist in his refusal to observe the reasonable requirements of the local authority, a local authority may then become subject to the duty again to provide accommodation. Okay, so we'll come on to discuss why that's important, which I think I do in the next slide. Yeah, so Cooch team, in that case, is seen as legal authority that the correct test for discharging duty is if the applicant manifests a persistent and unequivocal refusal to observe the requirements. Are they persistently breaching the rules? Is that unequivocal? Is that clear? Even if they are, a change in circumstances might assist. Okay. Now, Cooch team, that's the case that, as legal practitioners in homeless and housing law, we have referred to and arguing with local authorities in the past. There is a risk that, again, there's no case law decided in Scotland, and it's not the same statute. It was under the National Assistance Scheme in England. But yeah, I think this is authority for that. That's the approach. For better or worse, it might help in some circumstances, in others it might not. If a client has persistently broken the rules, but we'll come on to look at case studies and how we can perhaps argue. What I would suggest is that say you've got a client where you've tried to argue that they've not persistently broken the rules, or that there's been a change in circumstances and local authorities should take that into account. If we're considering whether there was a judicial review against the council, if they then refused to re-accommodate, one thing I would highlight, it's difficult in judicial review to challenge disputed facts. So yeah, I'd be interested in your experience, because it's not uncommon, I don't think, that you get someone saying, well, look, that didn't happen. Or, say the allegations related to a fight broke out or something, your client might say, well, it wasn't me, it was other person. But the difficulty with judicial review is that it's not really the arena where facts are led before the court. What the court's looking at is where the local authority entitled to make the decision that they made. So if the council have evidence available to it that allows them to make that conclusion or reach that conclusion, it's going to be difficult to challenge that without your own evidence. Okay. So yeah, it's just weighing that up as well, because it can be really difficult situations where you've got two versions of events, and your client's insistent that something did or didn't happen the way that the council said it happened. The more evidence that you can collect, the more facts, obviously, the stronger your argument might be. Jill?
That leads on to a question from Laura in the chat. She's asking, so when looking at whether the accommodation meets the client's needs, can that take into account things like proximity of the temporary accommodation to support services, schools, family, those kind of things?
Yeah, I think so. In the last session, when we looked at the unsuitable accommodation order, these locality issues are things that can be taken into account as well, and I think it can be relevant to needs. So, if you've got a client that does have a support service available to it, like a client who does have a support service nearby, for example, or needs access to that can be relevant to the suitability of temp. So yeah, I think when I've said look at whether the accommodation was suitable in the first place, like definitely look back at the slides from last time, because if there is an argument there that the accommodation wasn't suitable, I think you could argue that, you know, they still have the duty to provide temp. Okay, yeah, and then looking at a discharge of duty situation, you've got this, you get the scenario where a local authority might argue that, you know, this person's persistently broken the rules. So we'll come on to look at some case studies around that. I thought what I would do is just highlight like what you could do if you're looking to advocate on behalf of a client in this situation. And I've put some like bullet points down that might help, like just structure how you might write to local authority or email local authority on behalf of a client or service user. And again, it's just re-emphasising, like, was it suitable in the first place? If there's an argument that actually they've not performed the duty because the accommodation wasn't suitable, like make that argument and put that forward. Outline what the client's needs are, provide any support and evidence where you can. If there's behaviour, obviously there usually is a behaviour or conduct issue, can your client explain that? Is it related to any health issues? Are they remorseful? Are they now prepared to observe the reasonable rules? You know, you can say these things if that's what the client's saying. Are there support needs that have been identified by your service or another service, or indeed from the council's own assessment that are now in place or could be put in place that would help that person meet the requirements of wherever they're staying, help them to sustain their temporary accommodation? And if there's disputed facts, can you evidence that as well? Okay. So yeah, they can be tricky situations if you know, if there's a whole host of reasons that a local authority is saying, well, this person has been asked to leave, you know, 3 different accommodations, they're not complying with the rules. We'll start to tease that out. What's the reason for that? Are there support needs behind that? Are there health issues? You know, can that be explained? And can you put that to the council? I think it's also just worthwhile checking, well, was the client given any warnings? Have they been issued with a decision letter regarding the discharge of temp? I don't think there's necessarily a reason in the statute for them to give a decision letter, but some local authorities do. Is there a right to review or appeal that decision? So I think if a client's not been given any prior warnings, and you might want to check that with the council, but that might be an argument to say, well, look, you've not given a final warning here. And if there's not been a right to appeal, then you might want to say, well, look, would you just review this decision anyway because of X, Y, and Z? I think something also worthwhile looking at is, well, what's the consequences on the client? Where are they now staying? Is it forcing them to sleep rough? How is that affecting any particular needs that they have? So is it having an impact on mental health, addiction issues? You know, I think that's all important information to put to the council. And the reason that I say that is, like, let's look back at this quote from the Cooge team decision, where the applicant can satisfy the local authority that his needs remain such as to justify provision of accommodation, and there's no longer reason to think that he will persist in his refusal. So, you know, if the client's willing to accept that, okay, certain things happened, but there's a reason for that, there's an explanation behind it, it's related to support needs. You know, I'm now sleeping rough, I've got the support of this organisation, that's an argument that duty should be re-engaged. Okay. What I've also put here, and we'll cover the Equality Act in a lot more detail. We're going to have a lawyer-led workshop specifically on the Equality Act, and then how that applies to the different duties that councils have under the homeless legislation. But I think it's just important to, like, put this here as a marker, because there can be an argument under the Equality Act that discharge of temp duty may be discriminatory. And this is obviously if this can all be evidenced, so if the person has a disability under the Equality Act, and if it can be shown that the loss of accommodation is because of behaviour arising in consequence of that disability, then the onus becomes on the council to show that their action is proportionate. Okay, so it in a sense accentuates any challenge to discharge of duty. It complements any arguments that we've already talked about. And I've got an example here of what that means. So, you know, the client might not dispute the instance, but they've got a mental impairment that affects their behaviour. If you're able to get medical evidence that supports that, and you can show that there is actually a link between that behaviour and why the person's been lost their accommodation, you know, there may be an argument under the Quality Act that it would be discriminatory to discharge temp duty. I've just put some examples of like mental disorders that, you know, in my experience might apply to this kind of issue. So yeah, I think it's definitely worth keeping that in mind and taking that into account, and particularly if you can evidence it. And obviously some mental disorders, depending on the extent of severity of them, will be more linked to certain types of behaviour than others. But this can be relevant, and we'll put this here as a marker. We'll revisit it. We'll have a session on the Quality Act. What does disability mean? What does Section 15 discrimination arising from disability mean? We'll look at this test in a lot more detail and apply it to the different scenarios. But I thought I would flag it at this stage because it can be relevant, I think, especially in some of the more challenging cases. Yeah, and I put these slides here just as a recap. You know, if you've got a client in this situation, this really summarises what we've covered. Was the accommodation suitable for them in the first place? If not, why not? What are their needs? Has this, you know, can this be evidenced? Have the council in fact assessed these needs? Is there behaviour linked to the mental health or addiction issues that might mitigate the behaviour or explain it? And I've put that as a separate bullet point to the Quality Act issue because I think there's a distinction there, although obviously there can be an overlap. Yeah, are the allegations disputed? Is there evidence to support the position? So it's also worth just asking the question, well, is what the council is saying actually, does it demonstrate a persistent and unequivocal refusal? Are we talking a one-off isolated incident? Or is there a pattern here over a period of time? But even if you think you might struggle to say that it's not a persistent refusal, have the circumstances changed? You know, is the client now engaging with support? Even your service potentially might be an argument to say, well, look, they're getting support in place. They're looking to address their behaviour. They've got these needs. You know, sleeping enough is going to impact on their needs and so on. So hopefully that gives you some helpful pointers. We can go on to like the breakout rooms very shortly. I just thought I'd ask, you know, there's obviously quite a bit of experience of this situation in the room. Does this kind of ring true with folks, or how did you get on in your cases? Were you able to get the client back into temp? How did you do it? What were your arguments? Does anybody want to kind of put forward anything here? Okay, well, we can talk about it. You know, we'll have a chance in the smaller breakouts in a moment to, you know, to kind of tease some of this out. Hopefully you've received the email with the different case studies. So what we'll do is we'll go into 3 breakout rooms. Myself, Jill and Pauline we'll all take a session each, and we'll look at each of these case studies and come back, and we can try and apply what we've talked about to these case studies. And again, if you've got, like, feel free in the breakout rooms that if you've had your own situation, like, you know, we can bring that out and feedback to the group. So if you give me just a second, I will set up the rooms. Okay, welcome back everyone. Hopefully that was helpful to have a bit more detailed discussion around the case study. Pauline, would you like to, is it yourself that's feeding back or somebody from your...
Miriam from our group has kindly volunteered to feedback on our discussion. Miriam's from Foursquare here in Edinburgh.
Hi there. Yeah, so we were looking at this case study with Mr. Pritchard. We believed that the local authority perhaps did not perform their duty. There were various questions that we looked at, which, for example, I mean, did the local authority take into account their support needs, the mental health needs of Mr. Pritchard? Were the needs even assessed in the first place? Perhaps their behaviour was linked to mental health problems. We were debating on whether it actually really constitutes a kind of persistent and unequivocal refusal to obey the rules, basically. We were also asking, did he get a written final warning? If he didn't, then that would be another problem. Has he been given the opportunity to kind of show remorse and change his behaviour? Perhaps his circumstances have changed and perhaps he started engaging with support. Perhaps he started treatment for his addiction. We were also saying that the evidence would need to have been gathered with regards to the allegations of rule breaking. It can't be kind of a he said, she said thing, especially if there was a judicial review. As you said, there needs to be, it's quite easy to dispute the facts, and that doesn't really stand up. And yeah, so we were also discussing whether a curfew is actually a reasonable rule, and whether that could constitute an unsuitable accommodation order. If someone's repeatedly breaking a curfew, maybe there's a reason for that. Maybe they have work, or maybe they have family that they need to see, or support needs that could kind of take place out with that curfew time. We were also looking at the Equality Act and whether his persistent behaviour could be linked to his addiction or mental health. If there's any mental health problems, I mean, addiction in itself would be treated as a health issue, which would be, I mean, not taking this into account and discriminating against this would go against the Equality Act. The mental health issues or addictions could also be mitigating circumstances as to why he behaved in this way. So yeah, I mean, that's kind of a whistle-stop tour of what we were discussing. But yeah, there was quite a few things in there. So we said that we could probably start to ask for a review of the Section 29 for Mr. Pritchard.
Great, no, thank you, Miriam. As you say, lots of ground covered. I think possibly the case study that was emailed has the curfew thing, whereas this slide doesn't, because I realised that another example also has curfew, so I was trying to not make them all the same. So yeah, that's, if you're confused why curfew doesn't show on the screen, it's for that reason. But no, that's all really helpful stuff. The one thing I would say about the Equality Act, in fairness, we've not went into it in detail, but addiction issues per se are not treated as a disability under the Equality Act. Again, we'll visit this in a bit more detail. If there's addiction issues potentially arising as a consequence of a mental impairment, you know, there's potentially an argument that that does fall within the Equality Act. But we're starting to get a bit more technical, and I think that'd be worthwhile having the wider discussion, you know, at the next session that we do in the Equality Act. But yeah, no, I'm not, you know, I think the points you've made are all valid, because even if it's not an Equality Act argument, it could go towards demonstrating that you know, with appropriate support, he can sustain his temporary accommodation. You know, okay. Is that okay? Any other comments on that one from Polly, Miriam, anyone else? Okay, thank you so much.
Sorry to interrupt. I think Esther's got a question. Is that right, Esther?
Yeah, I was just going to ask around that, like in terms of addiction and stuff. Like, where does childhood trauma and you know, those kinds of things, or other kind of trauma, fall when it comes to Equalities Act? Do you know what I mean?
Yeah, no, it's yeah.
Would that be an argument if obviously there's addiction, but there's No.
It's flown from like an adverse childhood experience, or I think potentially. What I would also say is, like, in terms of arguing that they didn't perform their duty in the first place, that part of the code of guidance, if we go back to the unsuitable accommodation, assessing whether accommodation is unsuitable must take into account the needs of each member of the household, including protected characteristics, equality considerations, vulnerabilities around psychologically informed service delivery, and childhood trauma. So, whilst like the addiction issue itself might not allow for the Equality Act argument, it might allow for arguing that actually, well, let's look at how that's impacted on them and whether that accommodation was suitable in the first place. And you can tie it in that way. Okay, so yeah, I do think that would be a relevant fact, and that you'd want to put forward and support.
Can I jump in there? Is that all right?
Yeah, of course.
Comment. I guess some of my past experiences, if you've got a medical professional to back that up or some sort of evidence to support that, unfortunately, it may be relevant to the individual and they may be able to express their experience, but until we've got that wee bit of added extra evidence, then it unfortunately doesn't carry much weight, so always when I'm to say something, I'm always like, well, can we get some medical evidence to support that, or are you engaging with a psychologist or something like that? So it's always it's harder for the individual who've got to back up their claims, I guess, is the easiest way to say it. So yeah, but definitely having more evidence and as much as you can from medical professionals is always welcome. Sorry.
No, thank you, Scott. Really important point. And and it's not always easy, and often, like, you're up against the clock for a client who's potentially, rough sleeping, really vulnerable. But yeah, anything you can do to kind of uncover further evidence and produce that to the local authority, they have to take that into account. And that could potentially help with a legal challenge as well, if you do have the evidence to support what the client's saying. So yeah, thanks Esther and Scott for raising that.
Can I just ask? Sorry, it said at the bottom of that one that he had put in an appeal to challenge the discharge of duty.
Yes.
But it wasn't accommodated. Should the local authority have been providing temporary accommodation whilst that appeal was being decided, or does that duty not apply when you're appealing the discharge of temp duty?
Very good question. So the section 35A of the Act, which covers reviews, there's no statutory review for discharge of temp accommodation. So the duty to provide temp pending the review doesn't apply in this case in terms of what the statute says. Okay.
Okay. Thank you.
But that would be a nice answer if it did apply, for sure. But these are reviews or appeals that don't fall within the Act, so to speak. But there's an argument that they should provide that right of review or appeal, like with natural justice arguments. That if you're making a decision, you should be entitled to challenge it. So, for example, say you try to ask the council to reconsider or review / appeal their decision not to provide temp, and they says we don't have to do that. That would arguably be open to a legal challenge, because whilst there's no statutory duty for them to do that, is there an argument that the rules of natural justice require that they do give that opportunity, especially if they're provided with information that's relevant to how they perform their duties? But yeah, interesting question. Sorry, it's probably not the answer you were hoping for, but yeah, I think it leads to some stuff we can use. Great. Okay. Well, we're going to the second, Mr. Cooper's, I think. Is that yourself, Jill? Is that your?
Yeah, I'm going to feedback for the group. Okay. So the discussion's really totaled around sort of finding out more about, like maybe, getting the local authority to sort of, review their decision. I suppose finding out more about, has he got any health issues? Because we're saying there's been no diagnosed or there's no particular needs. Is that the case? the consequence of losing the temporary accommodation has resulted in rough sleeping, which is, not good for him. And also, he's vulnerable there at that point. But also, if there are issues there, does that make it even, worse? The fact that he's been sanctioned as well is, why has he been sanctioned? So finding out more information about that, and does that link with any maybe particular needs or issues he has? Also, if he is rough sleeping, that's a further disadvantage, because how does he keep up with that? We're assuming he's maybe on universal credit with sanctions. How does he maintain that, the sort of commitment that you'll have as a claimant? But also, has he not, because it's temporary accommodation, can he, getting to see if he can, looking at advice to see if he can apply for housing benefit to pay for accommodation? Because it feels, getting more information around those arrears as well. Has he been written to about them? How long have they accumulated? It feels like a small amount to suddenly just ask him to leave. So, yeah, finding out more information. If there are, if there's maybe a disability, looking at the Equality Act, and also the question around missing a curfew, is it just one curfew? Surely if he's missing, why is that temporary accommodation suitable for his needs? If he can't have access it all of the time, why is there a curfew? So is he in the right accommodation? Particularly if we find evidence to show that he needs maybe support. But yeah, I think it was more around gathering more information to then put in evidence to then challenge the local authority and find out if that is the best accommodation for him, or if they can review it and then provide other temporary accommodation as a result of that. I hope I've covered everything.
Yeah, thanks, Jill. Yeah, I think you're right. Like the issue about the benefit sanction is relevant here as well. Like, is that linked to why he can't, why he owes money to the B&B? It's probably a good question as to why he owes money to the B&B if he's on benefits and should potentially get housing benefit and so on. What did you think about whether there's been a persistent refusal to comply with the requirements in this case, Jill?
We discussed it. We thought, feels like maybe there hasn't been, because of the low level of rent. Like, how long has he not been paying? So it feels like maybe that's like a one-off, or a sort of small blip, really. And it feels like a really sort of knee-jerk reaction to discharge duty, when actually there could have been intervention in there to try and solve the problem, or the rent arrears. So we think that there hasn't been persistent. We would assume that, but again, we'd have to find out more.
Yeah, I think that's spot on. Like, this seemed, on the face of it, like from the information we've got, this is like a one-off. You owe us money, you're not paying it, you have to leave. So I would say, like, even in that point alone, there's a challenge against the local authority to provide temp in this scenario. Obviously, subject to all the further information that you've talked about. And I think as well, like, it's, well, is he now getting support? Is he linked in with a welfare rights advisor that's helping him get his benefits unsanctioned? And that can be put to local authority as well to say, well, look, this support should have been in place. It now is. That these are all arguments to say that they should, re-engage and provide temp. Yeah, and the curfew question is a duplication, obviously, for the first session. But yeah, look back at the slides from last time. But under Article 5, I can't remember what subparagraph it is, but accommodation is not suitable if it's not usable by a household 24 hours a day. So really, nobody should be getting accommodation that's subject to a curfew now. And yeah, that would be an argument as well, that even if this had been the 15th time that this gentleman had breached the rules, there's an argument that accommodation wasn't suitable in the first place. Okay, so yeah, it's all bringing out really interesting stuff. I think hopefully these case studies are starting to help demonstrate how you might argue, what you might investigate, and put forward in support of your clients.
Just one last thing before you move on to the next group. I was saying to the group, just because sort of learning, from today, that we could send out a link to the previous session on duty to provide suitable accommodation, so people can review that and this, and sort of maybe consolidate a bit more learning from both. So I thought that might be helpful. So I can do that after the fact.
Thanks, Jill. No, definitely. And that was the same in my group. There's people that have joined this session for the first time, or have only been to a couple. So yeah, have a look in the website as well, everyone, because there's links to like all the previous sessions, what we've covered. And if there's any session that you've not been to and you'd like the slides and the video for, just get in touch with us and we can get them sent out.
Chris, before we leave this one, we've just had a question. Someone just confirming, you said accommodation should not have curfews. Is that law or guidance?
So it's it's law and unsuitable accommodation order. Yeah. What I'll do is maybe during the break I'll find the relevant part for you. But yeah, it's basically with the extension of the unsuitable accommodation order to all homeless households, including single homeless people. That essentially has meant that certain types of accommodation shouldn't aren't suitable, so are challengeable. But yeah, I'll look that out. Okay. So my session was the last case study, and Chris, I believe, is going to discuss what we discussed. If you want to introduce yourself, Chris, sorry.
I'm Chris from the Rock Trust in Edinburgh. So we were talking about Mr. Donnarumma, who is asked to leave supported accommodation. So from the information that we're given there, like there's a lot of questions that need answered before we can really sort of know whether the council has met their duties or. So like the first thing that we spoke about was that all of the kind of reasons that it was asked to leave his supported accommodation are just allegations. So don't actually know if it's been proven or not. It's just sort of allegations. So we did ask like if he was actually charged with the possession of a knife and threatening. Was this a persistent thing? We don't really have any other information about has he been in previous accommodations. Fair enough, especially with the knife being found, it could endanger other residents. So like that would maybe be grounds to make them leave a supported accommodation without a sort of warning. But it could be a whole host of reasons why it was there. So I have the council investigated the mental health background, the kind of drug addiction issues. Or all it says really here is that he suffers from poor mental health, and that he denies the allegations. There's the question, if he has poor mental health, was he getting any support for this? Was the supported accommodation suitable for him with the poor mental health? It could have possibly been that he was in it for the mental health, but that information is not really there. How long was he there in the supported accommodation before he was caught, or before the allegations were made? Because if he was there for like a months or a year beforehand, then it could be that it's a sort of single instance of a thing, and maybe there is other reasons that could be found through sort of investigation. So in terms of whether it's a persistent refusal to not follow the rules of the accommodation, we don't know. So that would need to be found out. Different things that could be, or that if other organisations got involved? Like, was he offered kind of one-to-one sessions or counselling, anything like that? In terms of like appeals, for the Equality Act to come into activation, for it to be an Equality Act issue, the information there isn't clear enough to know whether this will be covered by that or not. So a detailed diagnosis would be needed rather than just he suffers from poor mental health, because this would allow it to be determined whether the behaviour is linked to the diagnosis. And again, the question would be, is he getting support for that? If not, could he get support for that? So all of these would have to be found before the council could really say no more temp accommodation.
Thanks, Chris, for feeding back. I think this one's quite a difficult one on the face of it in terms of like if these allegations are true. But yeah, you're right. It needs all this further investigation in relation to like support needs, mental health, addiction issues. Anything else from our group that wasn't covered? Does that cover it all? Scott, are you happy with that?
Yeah, seems good. Thanks, Chris.
Yeah. I'm thinking like putting my like lawyer's hat on. If this client was referred to me and the council were able to say, look, we've got evidence of these drugs. We know that the police have charged this individual. You'd want to be investigating, like whether there's an explanation for it. What's the client's position on these allegations? I think as well, one of the issues, I mean, if the client accepts that all this happened, it could start to be a trickier case. If for example, and I'm thinking of situations where clients maybe haven't engaged with services for years or been to their GP for years. Doesn't mean that they've not got a mental health condition or a disability, but proving that can be difficult. But we had a bit of a discussion in our session about evidence and things as far as possible. So yeah, these case studies are not necessarily easy, but hopefully it gives you some tools and ways of thinking about how you might investigate and advocate on behalf of clients in these situations. Any other comments or reflections on discharge of temp, having heard the different case studies? Okay. The one thing I would say as well is that and I've not put a slide in this, and perhaps I should have, but if you've got a situation that is really difficult, because say the client has lost umpteen accommodations over a sustained period of time, and you're not able to get a lot of support and information in relation to needs and so on, it's sometimes worthwhile just checking about what's happening with the permanent accommodation duty, if the council have that duty, because discharge of temp, even if that is lawful and the council are entitled to do that, doesn't mean that they still don't have the duty to secure permanent accommodation for an individual. So it can often be useful just to ask some questions around that as well. What's happening with the permanent accommodation? How long is he likely to have to wait for that? Has the person been waiting too long? And we'll talk about permanent accommodation duties in the next session, but I just thought that might provide a nice link, between the two different duties. And it's often something that, in practice, we start asking these questions of local authorities. If a homeless application was made 2 years ago and the person's been in temp all that time, and we think that a legal challenge might not be the most straightforward in terms of discharge of temp, well, might there be a legal challenge for permanent not yet being provided? As a ways that can be, you can advocate for that. So yeah, just flagging that is something that might be useful as well, just as a practice point. So yeah, this is just about the question about curfews. So yeah, the last session we spoke about how in May last year, the unsuitable accommodation order was extended to all homeless households, whereas previously it only applied to households with pregnant women or children. So these 4 parts of the unsuitable accommodation order potentially apply to B&Bs and hotels, and why they wouldn't be suitable. But Article 5F, if it's not usable by the household for 24 hours a day, then accommodation isn't suitable under the Act. So yeah, things like somebody losing their accommodation because they've breached the curfew, you know, I'd be arguing, well, you've not performed your duty because you've not provided accommodation that was suitable in the first place. The one proviso I would say is that these requirements are subject to the initial 7-day exemption, where local authorities can place you in unsuitable accommodation for 7 days. But yeah, go back. You know, we can make those slides available for those who haven't seen them, and you can look through them, get the recording if you want, and you can get up to speed on that. And then I realised there was a question from Michael in the chat just before we left. How is unequivocal being defined, interpreted? It's a good question. I think we would have to look at that decision again, the Cooch team decision. The dictionary definition is in a way that leaves no doubt. So I think that feeds into what we've been discussing around, you know, is it a one-off situation? You know, are they unequivocally breaching the rules? Well, is there evidence that they've broken the rules? Even if there is evidence, is it a one-off? And then I think probably what feeds into that as well is what we've talked about whether it's related to, you know, needs as well. Sorry, that's a very lawyerly answer, isn't it? But hey, what can I say? Occupational hazard. Yeah, so I don't know for sure. Like, there's a whole history of case law that kind of looks at different scenarios, but hopefully that starts to make a bit of sense. Right, so we'll move on then to permanent accommodation for the last half hour and the various duties that apply. So the local authority has a duty to secure permanent accommodation where someone is unintentionally homeless and where they've not decided to refer someone to another local authority because of local connection reasons. So effectively, if a council decides you're homeless, you're unintentionally homeless, and you've got a local connection to this area, they've got the duty to secure permanent accommodation. Okay. I put that out there. It's full of double negatives. Where they're not satisfied that he became homeless intentionally. That always gets me. But effectively, yeah, if you're homeless, if you're unintentionally homeless and you've got a local connection to the area, the local authority you've applied to will have the duty to secure permanent accommodation for you. Now, what do we mean by permanent accommodation? Well, the Act provides 3 different scenarios. Accommodation that's secured by a Scottish secure tenancy, so that's the standard secure tenancy in social housing. But it can also be secured by a short Scottish secure tenancy, where you've got less security of tenure, if there's grounds for granting that type of tenancy because of antisocial behaviour. I don't know to what extent you're familiar with short Scottish secure tenancies, but essentially there's various grounds that a local authority or a registered housing association, a registered social landlord can grant a short tenancy. And what the homeless provisions say is that if those grounds include the antisocial behaviour grounds, you know, permanent accommodation could mean a short Scottish secure tenancy. Not sure. Is somebody asking a question? It's not very clear. I don't know if it's just background.
I think you need to mute your thing because there's quite a lot of background noise again. Need to mute.
Okay. So yeah, I'm not going to go into those antisocial behaviour grounds in detail, but it includes things where antisocial behaviour order has been granted, but also like in such situations where there's been past antisocial behaviour. So it's just flagging that is a possibility, but again, you might want to just check whether they are entitled to offer a short Scottish secure tenancy. And then I don't know that a lot of people are aware of this, but a local authority can discharge their permanent duty by securing a private residential tenancy. So council could conceivably secure a PRT for someone and use the private sector. Any thoughts or issues or concerns around any of that?
That private landlords aren't always the most, how shall we put it, reliable or ethical.
Diplomatic as ever. And I think as well, another issue that we might think about is like affordability. You know, what's the rents in the private sector as well, compared with benefit, local housing allowance, entitlement, and so on. So that might be relevant when I come on to talk about, you know, can you challenge an offer of permanent accommodation if local authorities were starting to use this and affordability was an issue. Security of tenure is an interesting one, Grant, because with the introduction of private residential tenancies, they've got rid of the no fault ground for eviction. So whereas in short assured tenancies, you might, you know, after 6 months be facing a notice to quit and have to leave, PRTs can only be ended in certain grounds. So yeah, that's a whole separate discussion to think about to what extent PRTs do provide security of tenure and so on. But certainly the whole purpose behind them was to, you know, I think give greater security to private tenants compared with short assured tenancies. But I think the quid pro quo is that some of the grounds are easier to establish for landlords, for example, in terms of rent arrears and so on. So yeah, it's a good point, and we could spend a whole session talking about PRTs, but that's for a different project, I think.
Can I just ask, in terms of PRTs, so I've had cases before where my service user themselves has found a private let that they want to move into, or, you know, we've supported them with that process, and the council then discharged their duty once they've signed that tenancy agreement. But can it also be the case that the local authority themselves find a private let and say to the person, we found this for you, that like this is our offer of permanent accommodation, regardless of, you know, whether or not this is something that you wanted to consider or an area you want to live in, or like you obviously taking into account affordability and all of that. But I've only ever come across situations where that it's been done where it's been the client's choice, but can it also be done where it's the local authority doing it on behalf of the client?
So I think that's what that provision means, yeah, effectively. I think a local authority could secure, you know, and I don't know that whether this is happening. I've not come across it myself yet, but, you know, with increasing pressures on local authorities, is this something to be aware of? So yeah, and I think there would be concerns for, you know, particularly more vulnerable clients and service users when we think about the whole purpose of social housing and so on. So yeah, and I think that it surprises people that that's one of the ways in which a local authority could potentially discharge its permanent duty. So yeah, but yeah, I agree with you. Like, it would be subject to like affordability, and we'll come on to look at, well, when can you challenge an offer of permanent and on what grounds? And I think that's where you could start to use some of these arguments. I think your question also raised an interesting question, right? So someone applies as homeless, they're in temp, they get a decision, a positive decision, and the council has a duty to secure permanent, but as you say, they've got their own private let in the meantime. There's nothing in the Housing Scotland Act that says a local authority can overturn its decision. You know, that person who's got a private let is arguably no longer homeless. yet the council themselves haven't secured that accommodation. So do they arguably still have the duty to, you know, to secure accommodation, even though that person's got their own accommodation by another means? And I think that's an interesting point that's subject to, you know, I'm sure some litigation at some point, because I'm sure you'll get a local authority that says, well, we don't have to offer you anything, you're now no longer homeless. Yet the decision that the local authority made is that you are homeless, and we have got the duty to secure that, and there's nothing in the Act that says that they can withdraw that decision. So I think that raises an interesting question. So I thought I'd just flag that in case, you know, somebody's ever in that situation in the future. It might be worthwhile getting advice.
Chris, could I just ask on that, you know, in that scenario that Laura said that the local authority, you know, the client themselves has sourced that accommodation, that PRT, would you not say that it would be up to the local authorities to say, right, okay, where is that accommodation? Let's look at the affordability of that, you know, to work with the client to kind of make sure that it is the best option for them. Would that not be a duty of the local authority to do that, rather than saying, right, okay, that's fine, fair enough, but to make sure that it is, and go through the appropriate checks that they would had they sourced that accommodation for them themselves?
It's a good question, and I think there's possibly part of the Act that talks about advice and assistance that local authorities should provide. I'd probably have to go back and have a look at that particular issue, Pauline. But I think I think I can understand the scenario that Laura's kind of describing, because you know, some people are stuck in temp accommodation for such a long time that they feel they need to resolve it in their own way, you know. And there's no offer forthcoming. So yeah, interesting point. I'll maybe reflect on it and come back if that's okay.
Just a quick question on, like, is there an upper limit that the council have to offer to get someone out of temporary accommodation and into something permanent?
Time-wise, you mean?
Yeah, like a timeline.
No, and this is problematic because, like, obviously different local authorities are under different pressures in the bigger cities and so on. Like Edinburgh, you can be in temp for years. You know, it's an increasing issue, and the short answer is there's no like statutory like time limit on that. You're kind of entering into the territory of what's reasonable. You know, what's a reasonable period of time for the local authority to carry out its duties? Is it so unreasonable that no other local authority would take that long? That's starting to get into the kind of technicalities of a legal argument. But yeah, I think it flows on from what I was saying at the end of the first part of the session, where, you know, if you have had somebody in accommodation for such a lengthy period, it's probably worthwhile starting to explore what's actually happening there, and is there potentially a legal challenge to that? I don't think they're easy or straightforward, but you know, it's really difficult, and it's becoming increasingly difficult in some local authority areas, I think.
And so people can be in temporary accommodation for like years and years, like,
yeah,
like 5 years, like long time, or usually not.
I think I've certainly had experience of people being in like temp for at least a couple of years. I don't know if anybody else in the call has had longer than that. You know, I think if it's a couple of years, it's still.
See, I was in the hostel personally, and I know quite a few people that have been through similar shit. I've completely went blank there. What was I about to say? Sorry.
I think we're going to say we're going to talk about like the length of time waiting for permit, maybe.
Like I said, I was there for 8 months myself. I thought that was long, but there's people that have been there for 2.5 years, and one of them, like I said, it's touching on point from earlier on. It was bother he was having. Well, it was during COVID. Actually, they put him out, but because of COVID, they had to put him somewhere else.
Yeah,
it's still the same.
Yeah.
Or if you get put out now, can they actually just put you out and leave you out?
Well, I think that last part, that's probably like reflecting back on the first zero part of today, like if you're thrown out somewhere or you're asked to leave, like how do you get back in? But yeah, the permanent issue in terms of like how long it takes, and I see Grant's message as well. Large families can be an issue. Miriam, 2+ years in Edinburgh. So yeah, it is an issue, and it's possibly one for like the practitioner forum sessions to tease that out a bit more. And what I don't know that there's easy solutions, but you know, there might be legal remedies there, but it's not straightforward because it's not like the Act says you must be offered permanent accommodation within X, you know, period of time. I saw this in the Code of Guidance, where there's circumstances where councils can provide accommodation that's not permanent accommodation, where a housing support services assessment has concluded that the applicant requires a level of housing support services which makes permanent accommodation inappropriate. So it's obviously dealing with scenarios where there's like support needs, tenancy sustainment issues, and these regulations provide a means in which the local authority can provide accommodation that's not permanent if they've carried out that assessment. I just wondered, it's not something I've really come across myself in practice. Does anyone else have any experience of like non-permanent accommodation being offered because of support needs?
I've come across a situation where someone, because of the support needs, they've maybe been rehoused into like residential supported accommodation, or a period, a couple of years, for example. But I don't know how the council have worked it kind of technically at their end. But they've almost just kind of reinstated that person's previous homelessness decision when they've been ready to move on from that accommodation. So I don't think that they've not necessarily discharged their duty by accommodating that person in support accommodation. It's kind of seen as a temporary measure, and then they've picked up the duty once they've been ready to move on.
Yeah, and that's, I think, my kind of initial understanding of those regs. I'll maybe pick up on this again at a future workshop. I was interested in like what happens in practice, because I think the regulations say that if they are going to provide that non-permanent accommodation, the regulations still refer to like a short assured tenancy, which you can't grant now because of the PRT that we've talked about. So yeah, I can look into that a bit further. We can maybe touch on this in the future event. But I thought I'd flag it because it's there. It's in the Code of Guidance referred to as well, just to see what was happening on the on the ground. Okay, so turning back to permanent accommodation, I've started to outline what the Act says about what's not treated as accommodation or permanent accommodation, because this starts to open the avenues of like potential challenges. So local authorities shouldn't be offering accommodation that's overcrowded in terms of the legislation. What I would say is that overcrowding definition is quite wide, and it's actually quite difficult to sometimes say that a family is overcrowded in terms of the Act, because the living room can be treated as a bedroom in the definition of overcrowding, depending on the age and the gender of the children also impacts on whether there's overcrowding. So children under 10 aren't, children of different genders shouldn't be sharing a room, but it's okay to do that if they're under 10, for example. Children under 1 aren't included or counted, so there's all these like things that make it actually quite difficult for some families to be treated as overcrowded. I think there's a link in the toolkit that's on the website to the overcrowding legislation, or Shelter Legal's page, Shelter Scotland's page on that. An important one, I think, could be if the accommodation does not meet any special needs of the applicant and any other person referred to. That's a reference to MD that's reasonably expected to reside with the applicant, so essentially the applicant's family. If the accommodation that's offered doesn't meet the special needs of anybody in the homeless household, there's an argument that that should be treated as an offer of permanent accommodation. And then finally, we've got this catch-all if it's not reasonable for the applicant to occupy. And that's where you might have argued before with the local authority that, you know, that the offer that was made wasn't reasonable for them to occupy for various reasons. Also, which I think might be quite important, is the legislation, also provides that local authorities should have regard to the best interests of the dependent children to ensure that the accommodation provided is suitable for occupation by such children so far as consistent with their best interests. Okay, so we've got to take into account what's in the best interest of the children in determining whether the offer is a reasonable one. The Act also says that accommodation is only available for a person's occupation if it's available for both that person and any other person who might reasonably be expected to reside with them. So, don't know what that might cover, but you know, if a one-bedroom flat is offered and it's a family of 10, I think we're probably safe to say that that would be overcrowded, but also it would fall within this provision as well. So that's what the Act says about permanent offers of permanent accommodation. Can a permanent offer be challenged? So you've got the right to request a review of a decision, and the relevant part is section 35A to A and D. So the requirement to secure permanent accommodation is section 31(2) of the Act, and this specifies that you can seek a review of any decision in relation to section 31. What we're going to do is spend a lawyer-led workshop on like challenging decisions. So we'll cover reviews in a lot more detail, and we'll cover like how, you know, judicial review and so on as well. But I'm just putting this there as a marker. So you can seek a review of a decision that, you know, duties discharged because they've offered permanent. You can review an offer. So the first thing to ask is, are there grounds? And that's really just a recap of what we talked about just a few moments ago. Probably see a theme here that when we're always talking about challenging, is there evidence to support review? You know, can it be obtained? You know, anything you can get to support why someone might be thinking about refusing a permanent offer is obviously going to be beneficial to appealing that decision. A code of guidance might be helpful as well. Local authorities' duties to secure accommodation would be fulfilled by a single offer of housing, provided this offer was a reasonable one. What might be useful, depending on where you are or where the homeless applicant is that the guidance says that those experiencing homelessness should be treated on the same basis as other housing applicants. So some local authorities' allocations policy says, you know, if it's offer-based rather than bidding-based, we will make 2 offers of accommodation and no more. So if the allocation policy says that in relation to all housing applicants, homeless applicants should get 2 offers as well. Okay, I'm sorry I've not got any examples off the top of my head about what councils might have that in place, but it's just to keep that in mind. It's maybe always worthwhile checking what the council's own allocation policy says about offers. Because if it does say that you'll get 2 offers, you might be a bit more confident in refusing an offer, knowing that you're going to definitely get another offer, or that you should get another offer. Again, that might be just worthwhile clarifying with the council first of all before an offer is refused. You know, am I going to get another offer if I refuse this? Yeah, but I think this is important in terms of like if there's a potential challenge to whether an offer was reasonable. Local authorities should take into account the importance of offering a genuine choice of accommodation, as this is more likely to ensure sustainable resettlement. In considering what a reasonable offer, local authorities should take into account the particular circumstances and needs of the applicant and their household. So that might be useful if you're advocating or challenging a decision on behalf of a client. As a particular needs you can point to the code of guidance that council should be taking this into account. paragraph 512, would that accommodation pose a substantial risk to a person's health, which could include their mental health? Is it impracticable because of their physical infirmities or disabilities? Guidance also is this to say, again, on the theme of sustainability, poor practice might include placing people in hard-to-let housing, which merely exacerbates the problems which led to homelessness in the first place, leading to homelessness recurring, or placing families with social or other problems in the same area, which can cause problems for both those from the area itself and for housing management. So I suppose that's just been aware of, why is somebody in a homeless situation in the first place? Is it related to, I'm thinking out loud here, but, substance misuse issues? Are they being put back in a situation where, there's the area is known for those concerns? Was there issues with antisocial behaviour in that area that led to the homelessness in the first place? Is putting the person back in that area likely to lead to sustainment of a tenancy? So these sort of things just to consider. Obviously, it's all going to be fact sensitive. So yeah, but before we come on to scenarios and challenging decisions, I just thought a good practice point would be that if you are supporting a client through the process, identifying potential issues about suitability or reasonableness of an offer at the outset and raising these with the local authority probably as soon as possible is going to be far preferable to trying to challenge a decision after the offer's made and trying to set those boundaries and seeing if the local authority will take them into account. Grant, you've asked, as its code of guidance, how practical is it to hold the local authority to account on? Good question. What's the value of guidance? The Act does helpfully say that local authorities should have due regard to the guidance. So, if they're making a decision, they should at least be taking it into account. Again, to what extent they have to, or to what extent, what weight they have to play in that, what weight they have to place in the guidance is a different question. But if they totally disregard it and it's not clear from the decision that they have taken it into account, I think that would give a basis for a challenge potentially. Okay, so you're right. It's not legislation. It's not hard and fast law, but it is something that, if it could be established the council weren't taking it into account or hadn't, that might lead to a challenge. Great, I'm seeing that I've still got quite a few slides to go, and as usual, we're at 12:30 and I'm not finished yet. So if you do have to leave, obviously that's okay, you're free to go. You don't have to stick around. You can always get hold of the recording if you need to. I think it'll be 5 or 10 minutes more, so I'll press on so that we've got this for the recording anyway. But I appreciate I'm fast running out of time, but you're obviously welcome to hang around if you can. So, what issues might there be with offers of permanent accommodation? A relatively common one that I think I come across is location issues. Again, you can tell me if this reflects your own experience. But I put 3 different scenarios there. Permanent offers refused because it's too far away from the city centre. Permanent offers refused because the client suffers from severe mental health. The offer's half an hour away in the bus. The client has a support network where they live, which includes psychological support, friends who help provide support. And then you've got a permanent offers refused because the child suffers from autism, isn't in mainstream education, and offers across the city from the school. So, any observations? Those are 3 different scenarios. How strong a case do you think you could make based on what I've talked about in terms of reasonableness and so on? Are some cases here stronger than others?
I think in our experience, in terms of working with people that have been offered kind of accommodation on the last point, it's a bit easier to make that argument because of the equalities legislation.
Yeah.
But we've not always kind of been able to find kind of support to do that through kind of solicitors and stuff. I think the second argument is a bit more difficult because what we've seen with local authorities, particularly kind of we're predominantly in Glasgow where we're kind of offering services, is that local authorities will make the argument that like services are available across the city, so you can access the same support in a different location and it doesn't matter.
Yeah, and this is the kind of pushback that you get, isn't it? And it is difficult, and probably a lot of it comes down to like the evidence and the particular needs as well. So thanks, Grant, for like feeding back on your experience. I mean, I think with that second example, like if I had a client in that situation and I was able to get like a letter from psychological support service to say, you know, this client has strong links to this area, it's really important for their well-being and so on, I would certainly be like making an argument that the offer's not, you know, I think there is a basis to argue that it's not a reasonable offer, particularly when you go back to this slide. You know, it's not reasonable for that to occupy arguably relates to special needs as well. You know, does the person have special needs? I suppose the local authority might come back and say, well, it's to do with accommodation not meeting the special needs of the applicant. But I think there's, you know, in a wide interpretation of that, there's perhaps an argument to be made. But yeah, I think the more evidence that helps to demonstrate why like location is important, you know, the better it's going to be. Whereas that first example, you know, you're going to struggle, I think, if you've got that kind of bare argument that, look, it's just too far away from the city centre. You know, as you can probably appreciate, the more information and detail and needs that you can demonstrate, the stronger your case will be. Maybe there's an equality argument with the second one as well, if they've got particular needs that need to be met. But I do appreciate what you're saying, Grant, that it's not always straightforward. And, you know, if it was a client saying, well, my GP is in this area, I don't want to move the GP, you know, that in its own might be a struggle. But again, what's the reason for that? You know, are there reasons behind why they've got a relationship with that GP, or there are other services offered at that GP practice that might not be offered elsewhere? It's just trying to think through and tease out all these issues. Was there anybody wanting to come in on that at all? Anybody else?
I would just like to ask about the third one there as well. Like, I've literally got a girl who's in that exact situation. She's actually, her accommodation, she's hopefully going to be getting her wee boy back. He's been in care and a kinship, but it's just a one-bedroom flat, so that's an issue as well. I think they need to be providing, she's about to get in for overnight, so they need to be providing that, but also child does have autism and is about to be moved to out of mainstream education. So is that quite strong then, that really they do need to be providing something which is, you know, close-ish to the school?
Yeah, well, I think, the reason I put this one is like to kind of tease this out again, because like with these, I think with these issues, it is really fact sensitive, Esther. So I suppose, would you be able to get evidence, for example, that the child needs to be in a certain area, the routine would be disrupted, like they've got support in that area, it would be detrimental to their health or their condition if they did have to move. I don't, you know, in your situation, I suppose what the local authority might say is that, well, she hasn't been living with the parent anyway, so like, is there the necessity for that continuity? I'm just thinking out loud about potential arguments, you know. But I think what you'd be wanting to maybe do is try and make investigations as to, well, like, how important is it that the individual and the child is located in a particular area? If that's supported by like the psychologist, the child psychologist, whatever, you know, that could be really helpful to arguing that the offers should be in that area. And I think as well, like on the one bedroom thing, you're spot on, because as we saw that slide about, you know, it has to be suitable for people who are reasonably expected to reside with applicants. So again, if social work are able to support the fact that she is going to have overnight, you know, care and so on, So yeah, we get out, you know, as much evidence as possible and make sure that's given to the council. Did you say that an offer's already been made of permanent?
No, she's still in homeless accommodation, but overnights are starting, I think, this week or next week, and it's just, it is a one-bedroom place, so I think it's kind of imminent that they do need to get it sorted out. And at the moment, even the school that her wee boy's in, it's miles and miles away.
Okay.
Buses and everything, it's kind of a bit,
yeah. Well, if it's temporary accommodation, like definitely have a look at those slides for the previous session, because I think you can be arguing that it needs to be suitable for the overnight contact, and then there's all the standards to do with temporary accommodation around locality and access to services. Okay, so yeah, for temporary, I would argue that, and then I would also just be saying to the council as well that this needs to be taken into account for like the permanent offer. You know, because if you can front load all that, it's, you know, going to hopefully cause less issues at the other end.
Yeah. Okay. Thank you.
Okay, so yeah, it's these three examples really just to kind of tease out that, you know, a lot of this is kind of assessing the kind of prospects of how a challenge will, how successful a challenge might be, and it's not always clear cut, and it probably does depend on the particular circumstances and being able to evidence them. And the reason it can be quite high stakes, because if an offer is refused, the applicant then reviews and appeals that offer but isn't successful, the local authority may well have discharged their duty to provide permanent and no longer have that duty. So, I mean, that's obviously subject to whether that's then challengeable by judicial review, like by getting legal advice and so on. But these can be difficult situations because people are faced with a choice that they have to make. And if they do refuse an offer and then the review is not successful, yeah, it can be a really difficult situation. And the question I've got for everyone is, bearing that in mind, like should a permanent offer be accepted, even if it's considered an unreasonable offer, and that you're going to seek a review of it? And my question around that is, well, is it better that there's a fallback of at least a permanent offer? Any kind of initial thoughts or reflections on that?
Well, I think I would take Shelter's kind of online line on this and say that it's always better to have a fallback than have a discharge of duty and not be in any accommodation at all. And I think we've seen through our services people finding themselves discharged and having nowhere else to go, and us scrambling to try and rely on the relationships we have with housing associations to get people in permanent accommodation. And that's not a situation that I would want anybody to be in, because it's horrible.
Yeah, absolutely. And it's I think that's where I was reflecting. It's like quite high stakes for individuals, because, you know, if the potential only getting a one offer, so yeah, that fallback position could be important. I was speaking to some colleagues around this, and we were trying to like tease it out, because I was asking, well, what am I going to be saying tomorrow at this event about, you know, if an offer's made and the client's not sure about it, what do you do? I think there is a risk potentially that if an offer is accepted, if the client is then looking at judicial review or trying to legally challenge that, the client may have like acquiesced with the offer, like they've taken the offer, and particularly if they've moved in, you know, whilst they've been living there, they've sought the review's been unsuccessful, you know, by the time a case would get to court, you know, months later, you know, would that potentially undermine the argument that it wasn't reasonable to live in if the person has actually been able to live in it? And I think this is a really difficult question. I'm not coming here with like a hard or fast like answer. I don't think. It's just been alive to the fact that, you know, in your situation, Grant, you know, if a client has accepted the offer and you're appealing it and it's not successful, then it might be difficult to take that challenge any further, you know, if they have accepted the offer and they're living in that permanent accommodation. But at the same time, there's surely examples where that just wouldn't be appropriate. And if, you know, domestic abuse situations, is there a risk of that if they go to a particular area? External violence, and again, that probably all comes down to like whether it can be evidenced and so on as well. So I think it's probably one for like a client to like weigh the risks and to support a client in doing that and assessing the prospects of how likely is a review going to be successful. If you get really strong evidence that supports your client's case, that they shouldn't be, that offer is not reasonable and that another offer should be made. So it's a bit of it's not a clear-cut answer, I don't think. And I can understand completely if clients take the view that they would prefer to take the safe option and have that fallback position. But it's just to be alive to the fact that there may well be situations where that's not appropriate. But you might want to make sure you've got the client has as much support and evidence as possible. Because if number one, this first client refused the offer and sought a review, the likelihood is that review is not going to be successful based on that kind of only fact. Whereas at least if they'd accepted the offer and reviewed it, they've got that as a fallback if the review is not successful.
Can they, if they review it, or can they, and this, it fails, can they still take the accommodation? Like is that still an option, as a fallback?
It's a good question. I think often an offer is made and you're given X amount of time to confirm if you're going to accept it in practice. And I think there was potentially a legal challenge at one point to say that local authorities should keep the offer open pending the review. But I don't know that, I've never heard an outcome of that, so I don't know if it's settled or didn't actually, get to challenge. So I think that point's still to be tested. But I think it's difficult because, reviews can take a while to be decided. Local authorities are under pressure, RSLs are under pressure to let their stock. So yeah, ideally, there would be a holding position. Like, I don't agree that this is reasonable. We hold it pending the review, but I think in practice that doesn't happen because of the timescales. Okay. Oh my goodness, I've got another part as well. We're at 1:45. I'll press on, but if there's less and less faces on the screen, I won't take it personally. Yeah, so we've covered a permanent offer, reviewing a permanent offer, like circumstances in which you might be able to challenge it. Some of these tricky issues involved. What about other situations? So yeah, Section 31, which is where the permanent duty arises, it only applies where the local authority is satisfied that the applicant is homeless. So if the decision is you're not homeless, you might not be surprised to hear that the local authority are not going to have an obligation to provide permanent accommodation. What about where there's no duty to secure permanent? So if the council decide that you're intentionally homeless, what happens then? So they've had to provide temporary accommodation pending that decision. Say they decide that you're intentionally homeless, you review that, they have to provide temporary accommodation pending the review decision. The review decision upholds the council's original decision. So you're intentionally homeless. What does the council have to do then? Well, they have to continue to provide accommodation, which is temporary, for such period as they consider will give a reasonable opportunity of securing accommodation. So the council don't have the duty to secure the permanent, but they have to give accommodation until the person's able to secure their own accommodation, or to give them a reasonable opportunity of doing that. So in the example we heard earlier, I think it was yourself, Laura, that was saying, the person sorted their own, private let out. That might be one housing option that a person is going to look at in a situation where they're intentionally homeless. So council should give accommodation for a reasonable period to allow that person to try and secure their own accommodation, whether that's through housing association waiting lists or private rented accommodation. And also, quite importantly, they have to give advice and assistance as well in attempts to secure that accommodation. So it's not the case that you're intentionally homeless, right? You have to leave or it shouldn't be the case that you have to leave in 28 days if no advice has been provided and they've not given you a reasonable period of trying to secure your own accommodation. And again, that's going to be fact sensitive, because what's a reasonable opportunity for one person might be different for another family, for example, who might be struggling to get accommodation that's large enough for them. is affordable, and so on. So again, that's going to be fact sensitive, but in the meantime, pending that reasonable opportunity, accommodation should be provided. The Code of Guidance talks about, the consideration of factors that should be taken into account as to what counts as a reasonable opportunity, and it takes into account the person's needs and affordability, quite importantly. So if a local authority is saying, look, we're going to end your current accommodation, we've given you a reasonable opportunity of securing your own accommodation. Like, if the person was able to evidence that, well, actually, here's all the private lets I've inquired with, and they're all £100 above the local housing allowance that I'd be entitled to, I couldn't afford that. You can start to see why, okay, the local authority may well have a duty to continue to accommodate until they're able to find something affordable. Again, all going to be fact sensitive, and the Code of Guidance supports this as well. But if the authority if the council have given advice and assistance, taking into account the availability of alternative accommodation and the needs of the applicant, but there's been no reasonable options identified, like the Code of Guidance is clear that the council shouldn't be then saying, well, you've had your reasonable opportunity, we're going to stop accommodating you. If the person has no local connection, Pauline covered this in her online workshop, so I'm not going to dwell on local connection, but you can get access to those slides, I believe. But in a situation where council has decided, oh, you've not got local connection to Glasgow, but you have to South Lanarkshire, we're going to refer you there. The duty is on Glasgow to provide accommodation, temporary accommodation, pending the referral being accepted by South Lanarkshire. So you often get situations where local authorities try and play off their duties on the other local authority. But the law is clear, it's on the referring local authority to accommodate until such times as the authority that does have a local connection accepting the duty, upon which time it then becomes the new local authority's obligation. And if, in that scenario that I described, if South Lanarkshire say, look, the conditions for referral aren't met here, it's on Glasgow to continue to accommodate. We made it only 21 minutes late. Covering quite a lot of ground, both on temp and permanent. Sorry if the last section was particularly quite rushed. Whilst we're all here, I'll open the floor. Happy to answer any questions, or if anybody's got any comments or observations. Hopefully it's been helpful and might help with some of the situations your clients might be in. And if you have got any follow-up, do feel free to ping us an email. We can do that. If you get something that you want maybe covered in a bit more detail in a future session, get in touch. We're happy to be flexible and see what we can plan ahead for the future. But yeah, thank you all so much for coming along, sticking with it, and contributing to the breakouts. Thanks to Pauline and Jill for helping out with them. Yeah, and I hope the rest of your day goes well. Thanks so much. Nice to see you all again.
Thank you.
Cheers.
Bye-bye.
Thank you.
Bye.
Bye.